Good afternoon, everyone. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin, the Western Canada practice lead. Thanks for joining me today. We're doing an employment law Q&A this afternoon, where I'll be answering your questions, anything you have related to your rights under employment laws. So feel free to put your questions in the chat. We're going to get to as many of those questions as we can today. So put your questions in the chat, and we'll be getting to those as quickly as they come in. While we wait for that to happen, the big news here in Alberta, where I'm located, in terms of employment rights, has been the recent announcement by Imperial Oil that they will be reducing the headcount at their in Calgary or in Alberta more generally by 20%, affecting employees in Calgary mostly. Of course, when your employment is terminated because of a restructuring, a downsizing, or something like that, of course, that's a without cause termination. You're entitled to severance in those situations. We often talk about severance. People often ask me, Luke, what is it? Is it a week per year? Is it 2 weeks per year? I've heard 4 weeks per year. Which one is it, Luke? I'm trying to figure out how much severance am I entitled to? Well, the answer is none of those are actually right, all right, because it isn't necessarily an amount of weeks per year. A lot of other factors go into it, including your age, your length of service, the type of job that you had when you were terminated, and the type of economy that you're being dropped into as a result of your termination. Is it a booming economy? Is it a recession? Those things impact how much severance you might be entitled to. So if you're concerned that you've lost your job and you're trying to evaluate, have I received a fair offer from my employer? Or if you're concerned that, a termination might be in the pipeline for you, best thing to do is to know what your entitlements are. So I always invite people to reach out and use our online severance pay calculator. It's a tool that we've developed here at the firm to allow you on your own to figure out how much severance you might be entitled to. It's very simple, easy to use, free of charge, of course. And all we really ask is answers to those 4 questions. How old are you? How long have you been with your company? What kind of job did you have? Right? And how much did you earn, so that we have an idea of how much severance you might be entitled to and what that means, both in terms of length of severance and also in terms of dollar value. All right. And there's no obligation, but you should have an idea of what your entitlements might be worth. So if you're interested in that, free of charge, as I said, to consult, you can simply visit pocketemploymentlawyer.ca. We have the website on the screen there. Pocketemploymentlawyer.ca. Within 30 seconds, we'll have an answer for you once you've answered those 4 questions. All right. So we've had some questions come in. Let's start off with Barry. Barry is asking, I applied for EI sickness benefits recently and noticed my employer hasn't issued my ROE yet. My boss says they have to wait until I receive my final pay before they can file it. I thought the ROE had to be submitted within 5 days of my last day work, not my final pay. Am I misunderstanding what last day of work means? I can't find anything about final pay in the guidelines. I'm not aware of any final pay requirement either, Barry. My understanding, though, it says 7 days worked. Okay, so if you haven't worked in 7 days, then that's usually when an ROE needs to be issued, is my understanding of it. You can, contact EI directly. They'll both be able to, elucidate for you whether it's 5 days from your last day work, 7 days, or from your last pay, or which one is it. But also, if your employer is late in getting the ROE out, they can follow up with them to get that ROE, because you will not be able to receive EI sickness entitlements until that's straightened out. So very first step would be, Barry, stop arguing with your employer about this, contact EI and let them chase your employer for this record of employment. It's going to be a lot more effective. So get in touch with EI, tell your employer you've been in touch with EI. You can then tell your employer, EI told me from the horse's mouth, I heard that you have to get this ROE in ASAP so that I can collect my EI sickness benefits. And then you have EI also contacting them to go after getting that ROE filed as soon as possible. All right. So first step, I would say, Barry, contact EI, Service Canada rather. They administer EI, and they'll be able to help you further. We have another question coming in from Taylor. Taylor is asking, my employer monitors all our keystrokes and records video during remote workout hours. Is that even legal? Okay. So it kind of depends where you are, Taylor. So it's not illegal. Um, in Ontario, there's a requirement that your employer have a policy about remote monitoring. There's no such requirement in Alberta or BC, where we also operate. But in Ontario, there has to be a policy that you're aware of that explains what's happening there. So that's the requirement, but then the policy can say, we're totally allowed to monitor you here. So is this an area where the law has not caught up with the technology? Possibly, likely, in fact, where we are in a situation of remote work where, the traditional forms of supervision no longer apply, and what comes in its place, and is it not a little bit draconian, frankly, that your keystrokes are being monitored, that they can, access your computer camera at all times and stuff like that. So if this is something that's new to you, or that they're doing without actually informing you of it, potentially that can amount to a constructive dismissal, all right? Because surveillance in the workplace has been around for a while now, through video cameras and key, key punches and all of that. There has been some surveillance. It's been dealt with by the courts, by union arbitrators and things like that in the past. There are limits to it. But it is established that employers have the right to use these kind of surveillance technologies to monitor the productivity of their staff, but that also staff have a certain diminished but still existent right to privacy in the workplace. All right. So of course, they can't be putting cameras in the toilets and things like that. So where does that kind of line go in terms of remote work and keystroke monitoring and generally, accessing your camera and stuff like that? That's where kind of the official law, the employment standards legislations that we have are not necessarily where they need to be. But if there is egregious monitoring of you without your knowledge, then that can amount to a constructive dismissal. If you are in Alberta and BC, you also have rights through privacy legislation. And so there are some privacy guidelines issued for workplace surveillance that you can consult by either visiting the website of the Alberta Privacy Commissioner, the BC Privacy Commissioner, or by making a complaint. All right, and so these privacy commissioners will help ensure that there are some guardrails on this technology that really can track every moment of your day for you, right? So that would be an option to explore as well, and something to go through if the monitoring is not so outrageous that it amounts to a constructive dismissal, and you still want some guardrails on it, on how this information, this data will be used. Then a good idea is to get the privacy commissioner involved to make sure that your employer is complying with privacy legislation. All right, we have another question coming in from Jax. Jax is asking, I'm not a salary employee. How many sick days can I take before it's an issue, before they can fire me for it? So there's no real rule in the line in the sand there either, Jax, on how many days you can take. A lot of, all employees in Canada, or at least in BC, Alberta, Ontario, and federally, have human rights protections. All right, and so part of the issue that people who take a lot of sick days or have to take leaves of absence is that they're doing it because of medical reasons, and some of those medical reasons may rise to the level of a disability. So I'm not saying you got a cough today, you got a sniffles, you have to take the day off. You ate something at lunch, it's not sitting well, you need to take this day off. That we wouldn't call that a disability, frankly. But if you are having some sort of chronic issue that requires you from time to time to take some more sick days than average, that can amount to a disability. And so if you are disciplined for taking sick days, terminated for taking sick days, and you're taking those sick days as a result of your disability, that can amount to human rights discrimination. All right. So obviously, that's something that if I'm advising an employer to be of concern of, if they're coming to me and saying, well, I have an employee, Jax, he's taking a lot of sick days or she's taking a lot of sick days, I'll be asking them, well, do you know why they're taking these sick days? Is it because they have a disability, right? So definitely something to be cognizant of. But if it's not a disability, and if you're not actually sick, then that can become a problem as well for you, in the sense that if you're taking unauthorized sick days, you can be disciplined up to and including termination. Okay, generally, if you're taking too many sick days, your employers should use progressive discipline. All right, Jax. So if no one has told you, listen, Jax, these sick days are getting out of hand, cool it or else, then you still expect that they would be required to do that. All right. I mean, before they terminate you, they'd have to sit you down, tell you, listen, we're warning you, this is too much. You keep this up, we're going to be terminating. All right. So keep that in mind, right? I mean, it would be very hard for an employer to say, well, one day, Jax took 20 days sick day. Our policy is that we just terminate in that situation. There's no kind of mitigating, aggravating factors we consider. We have a hard and fast rule. You take a certain amount of sick days, you're terminated. All right. Frankly, they could terminate you on a without cause basis, but they couldn't say that amounted to just cause. All right. Now, they can't terminate you on a without cause basis, even if it's due to a disability. That still amounts to discrimination. But if you're taking a lot of sick days, it's not because you have a disability and the employer doesn't like it. They can always terminate you with a severance package. Isn't much that we can do about that. All right. The employer is entitled to terminate its employees on a without cause basis, so long as they provide you with adequate severance, and so long as it's not discriminatory, it's not retaliation for having tried to enforce your employment standards rights, and it's not for having taken employment standards protected leave of absence. All right, so they can terminate you in those situations. So that's kind of my long-winded answer to your question, Jax. I hope it helps. If I haven't clarified it to your liking, feel free to ask a follow-up question. I'll try to get to as much information as I can for you on this issue. We have another question coming in from TT. An employee at our event rental company accidentally backed a company truck and trailer into a customer's car during a job. The owner says the employee must either pay the $2,500 in damage or go through their personal insurance. I've been asked to inform the employee, but I'm unsure if that is the correct or legal approach. Since the employee was on the job using a company vehicle, is it really their responsibility to cover the damages? So, TT, what I can tell you is that this is a question that's both an employment law question, but it's also an insurance law question. All right. So I do not know who your insurance, because obviously this employee probably has their own vehicle insurance on their own vehicle, and your company probably has vehicle insurance on the vehicle that crashed into the car, and there are probably rules about which insurance applies here. That the insurance companies can inform you on. All right. Beyond that, the employer is not going to have a lot of sympathy from the employment law side of things on having the employee pay for his damages. It seems to be accidental. It doesn't seem to me that from anything you've said that this was done on purpose. And so if it's an accident, then that's usually the employer's responsibility to assume the consequences of that accident. All right. So if your employee destroys something at work accidentally, messes something up that creates, losses, you can discipline them. You can say, well, listen, we're going to use progressive discipline on you, as I was just discussing. But you can't require the employee to pay for those damages. What you especially cannot do is, what is called in the legal circle self-help. You cannot deduct from that employee's wages the $2,500 that is owing on this damaged vehicle. Okay, if you try to deduct this from the wages, it's an illegal deduction. The employee can go to the Ministry of Labor. They'll start an investigation, and they will force you to pay that amount and potentially to pay a fine or a penalty or an administrative fee, as they call it. All right. So if you decide, well, we're not going to deduct it from wages, we're just going to sue this employee in small claims. Again, the law is clear that if your employee was simply negligent and that resulted in losses, the employer is usually the one that has to pay for those for that. All right, not the employee. And that's when there isn't an insurance company in the background. All right, here we seem to have 2, potentially 3 insurance companies involved. They probably have. This is probably not the first time this has happened to them. They probably have some procedures on how to deal with that. All right. So that's what I wanted to tell you, TT. I don't think your employer is in the right to say that this has to be paid by the employee or their vehicle insurance. So there you have it. We got a question coming in from Marcus. Marcus is asking, I just got laid off without warning. They said it was due to restructuring. Am I entitled to any severance or notice? All right. So one thing I want to clarify, a lot of people use the word laid off for terminated. All right. So if you've been terminated, is because, sometimes people call that a permanent layoff. All right. So you've been told there's no more work for you. There's not going to be more work for you. Go ahead and go look for another job. Your time with us is done, unfortunately, and it's due to a restructuring. Okay. That's a permanent layoff. Another type of layoff might be a temporary layoff, where they're saying, well, listen, actually, we're going to be slow for the next 2 to 3 weeks, next 4 weeks. Stay home. We're not going to pay you. And then in 4 weeks, we're going to recall you when work picks up. Okay. That's a temporary layoff. All right. So a permanent layoff is essentially a termination. You've been terminated. You've been let go. You've been fired. You are entitled to severance. If it's truly because of restructuring, they're not saying that you did anything to warrant this termination. They're not saying they have just cause to terminate you. So you are owed severance. Yes, you are, Marcus. You might be asking yourself, well, how much severance, how much notice am I entitled to? So as you were here at the start of the show, I was talking about our nifty severance pay calculator. It's a free tool that we have available for all of you to use to figure out how much severance you might be owed if you were terminated today. So Marcus, it's up there on the screen, pocketemploymentlawyer.ca. That's where you go to figure out how much severance you might be owed. Okay. Now, if you have been temporarily laid off, things are getting rocky at work. We don't know when the next contract is coming up. We got to lay you off temporarily. We're not terminating you. We're just laying you off temporarily. We're going to call you back. Just hold tight. Listen, your employer is not allowed to do that unless you have given them permission to do that. How do you give permission to your employer to lay you off? Either A, when you started working there, you sign an employment contract that gives the employer the power to lay you off if they want to, all right? Or B, you've been laid off before, you went along with it, and when you were recalled, you came back to work. So that's established a practice of them being allowed to lay you off, all right? If neither of those things happen, in the sense that this is a first layoff and you haven't signed a contract giving your employer the right to lay you off, you can treat this layoff as a termination. You might be looking at this and saying, well, listen, I can read the cards that you're dealing me here. Things are rocky. I'm not going to stick around and wait. I'm going to go after my severance right away. A layoff is a constructive dismissal. All right. It means that the employer has essentially terminated you, but hasn't used the words you're terminated. You do not have to accept the layoff. You do not have to sit idly by at home waiting for them to call you back. You can treat the layoff as a termination and go after your severance right away. All right. And if that's what you want to do after you've reviewed your severance entitlement on our website, on our severance pay calculator, give us a call. It's as easy as going on our website, employmentlawyer.ca. We're always happy to talk with you. Most of our consultations are free of charge. So if you, not all, unfortunately, but a lot of them are. So if you want to speak to one of our lawyers, see, like, what are my severance entitlements and how do I go about getting them? Pick up the phone and reach out to us. We're happy to talk to you. All right. So that's the answer to that. So main takeaway is layoff can either be temporary, in which case the employer is saying, we're going to call you back, just hold tight, or it can be permanent, in which case it's a termination, and there's no constructive termination about it. You've been terminated. They've spelled it out for you. You're not coming back, right? So in that case, in both cases, you're owed severance, frankly. But in that case, it's especially clear that you're owed severance. So, Marcus, if your employer has not made you a severance offer, then it's important you contact us as soon as possible because you are owed severance. All right. All right. We have another question coming in from Sasha. Sasha is asking, can I be fired for refusing to work on a statutory holiday? I thought we could opt out. The employment laws, as they are today, do not necessarily allow you to opt out of statutory holiday. What they provide is that if you are required to work on a statutory holiday, you can get stat holiday pay, which is time and a half in a lot of places, on top of your statutory holiday pay, right? So imagine, Thanksgiving, you get a paid day off. If you have to work that day, you get additionally to your paid day off salary, you get a time and a half on that day. All right. So you could be end up making two times and a half your regular salary. But if your employer has scheduled for you for that day and you're normally scheduled to work that day, you don't have an absolute right to say, no, it's a statutory holiday. You can't force me to work. All right. So yeah, just wanted to highlight that for you, Sasha. We have another question coming in from Brave Princess. With the Alberta teacher strike starting October 6, 2025, disrupting childcare, does family status protection under the Alberta Human Rights Act apply to affected parents? Brave Princess continues, what are an employer's duty to accommodate these needs? Can they require using vacation time? And if the employee has no vacation or sick time left, what further accommodations must they provide? Can employer force unpaid leave? All right. So, Brave Princess, yes, we are in a situation here in Alberta where kids can't go to school right now because the teachers are on strike. Parents rather are left scrambling as to what they're going to do with their kids while they're supposed to be at work. All right. So there is, you're right, such a thing as family status protection under under Alberta human rights legislation. What that means is that your employer has a duty to accommodate your family status needs up to the point of undue hardship. Okay. Before that duty to accommodate is triggered from your employer, though, you have to try to see if you can self-accommodate yourself. So, what have you done to see if someone can take care of your kids, either by placing them in some sort of daycare, seeing if there's someone else who can take care of them who's available, a family member, a grandparent, an aunt, an uncle, seeing if you and your neighbors can, or your children's schoolmates can organize. They'll go to your house on Tuesday, they'll come to mine on Wednesday, so you don't have to take every day off, right? What can you do to minimize the impact for your employer within reason? Because it's not just your preference that needs to be accommodated. So listen, if it's not me, it's no one, and I have to legally provide supervision to this child because they're too young to be on their own. All right, and of course, then the age of the student also plays a role. Are they, in first grade? Are they, graduating high school? They'll have those kids will have different needs. All right. But then if you are in a situation where there's no daycare, no grandparents, young children, no one to help out, you need time off to supervise this child, your employer has a duty to accommodate you. Okay. Your employer can require that you use vacation time if you have vacation time. and can require that you take the time off as job protected leave, but unpaid leave. Okay. They're not required to pay you, but your leave would be job protected in the sense that they can't say, well, you're not coming to work anymore. We understand from that you're resigning. We're not holding your job anymore. We'll see you later. All right. It's a job protected leave. All right. So that's where the law stands. Your employer is not required to pay you for not being at work. They can require you to use your vacation time, but your job is protected if you need time off to take care of your children. Not an ideal situation by any means. I'm not saying that it's ideal for anyone. Employers, employees, parents, all of that. But that's kind of where we stand right now. That's the state of the law. We have another question coming in from Carmen. Carmen is asking, my employer has announced the intent of relocating the office to Edmonton from Calgary in 2028. Is this grounds for constructive dismissal? Do I need to resign ASAP to avoid appearing to consent? Okay. So yes, normally a move, so you're working, let's say 30 minutes away from your office, and now you're going to be asked to work somewhere. Well, you'll have to relocate. There's no realistic way that you can commute to Edmonton on a daily basis for your job. So that's a constructive dismissal, all right? Unless your contract has language to the effect, that we can relocate you at will, and that you would have agreed to when you started working there. So you'd have to first look at your contract, make sure that it's not there. It's in there in some contracts, by no means the majority of contracts, so it might not be in your contract, all right? This is precisely what's kind of happening in the Imperiola situation, where basically a lot of Calgary employees are actually being terminated and things are being consolidated in Edmonton. All right. So I guess some employees may be asked to move to Edmonton. And then if that's your situation, you're being asked to move to Edmonton, really you have to make a decision now. Do you want to move and keep your job, or stay in Calgary and potentially lose your job? So if you've decided you don't want to move to Edmonton and you're ready to walk away from this job, then yes, it's important you contact us as soon as possible so that we can navigate this with you, because it is possible. Listen, frankly, you should express that you have no intention of going to Edmonton. I suggest you speak with us first. There's a way of doing it to ensure that your legal rights are protected, all right? You shouldn't lay in the weeds and then at the last hour necessarily tell your employer, actually, I'm not coming to Edmonton. I don't know why you thought I would. I never had any intention. Better, I think, in these types of situations to be above board with everyone, so everyone kind of knows where they stand, all right? So that's my advice to you. But I think constructive dismissal is the area of law that's most complicated for employees to get right, because here you're wondering, rightly so, will I be deemed to have accepted the change? Will I be deemed to have resigned, and all of that? And there's a way of navigating that to protect your legal rights. It's important to do that with the assistance of a lawyer. So feel free to reach out to us. If you're looking for how to reach us, you have the website on the screen there, employmentlawyer.ca. Navarro TT is asking, when can an employer change things like commission pay? Is moving people off of a commission salary allowed? So essentially it comes down, Navarro, to whether it amounts to a constructive dismissal, all right? So you'll be surprised maybe to hear that you'd figure, a 3% drop in salary, and to some people's eye, would be a constructive dismissal. Like, why would I accept to pay for work for less than I did before? But in fact, it has to be a substantial reduction in salary for it to amount to a constructive dismissal. And what do we mean by substantial? We mean something in the vicinity of 10% or more reduction in salary before it amounts to a constructive dismissal on its own. It can be less if there are other things happening. There's a demotion, there's a move to another location, there's a reduction in job duties and stuff like that. But if it's really just a pure reduction in salary, we're looking at 10% or more before really we're starting to talk about constructive dismissal. When it comes to commissions, it can be even a little bit more complicated, because commissions are performance-based compensation, and so the performance fluctuates, the results fluctuate, the commission fluctuates, right? So there's going to be a natural amount of fluctuation in your commission salary for year over year compared to someone who's on a fixed salary, right? But even with that, I see it all the time. Employers come in and say, well, actually, this commission structure that you had, we're changing it. And when it shakes out, you're like, this is not a change, this is a reduction. You're actually paying me less commission. I look at if I apply this commission structure that you're giving me now to what I earned last year, it's a reduction in the commission. It's a reduction of X amount. I can see it right here. You were paying me 3% on new sales. Now you're paying me 2% on new sales. New sales generated half my salary, and now you just reduced them by 2/3. That's a reduction. That can amount to a constructive dismissal. Basically, you run the scenarios and see that, there's nothing to offset that loss of that 1 percentage point. So it's just a straight loss of salary for you, right? Other times it's a bit more complicated to see. They'll reduce the commission percentage, for instance, but they might increase your base salary. They might, increase the value of your leads or something like that. And it's kind of hard to see whether this will be a reduction in salary, an increase in compensation. What is it, right? And that's where it gets a bit trickier to see if that's allowed. But generally, what I see is employers saying, well, actually, we think we're paying our salespeople too much. We're going to reduce the compensation, the commission compensation they receive. And that oftentimes is a constructive dismissal. Again, Navarro, it's complicated. So I don't want you to think you just say, well, listen, I look at these two plans, they're different, therefore I'm constructively dismissed. I recommend that you reach out to us, speak to us, let us figure out, what this commission would mean for you in terms of percentage, loss of salary, and then come to a determination based on our experience of how these cases usually go, whether this amounts to a constructive dismissal or not. All right. So if you're looking to have that evaluation done, reach out to us. Employmentlawyer.ca is how you can contact us. All right. And we have a Brave Princess. Thanks you for clarifying this on the family status. We have Merle B. Sweet Life saying hi, everyone. Hi, Merle B. Sorry, thanks for joining. And we have time for one last question from Carmen. So Carmen is the one who's being relocated to Edmonton, and she's continuing. If my contract states that my organization has offices Canada-wide, and I may be asked to relocate or transfer to these locations in my career, does that prevent constructive dismissal? It can. Okay, Carmen. I want to see this contract essentially, and see what the practice has been. It can. Yeah, that's precisely the kind of language that seems to give your employer the right to have you relocate. All right. So that's definitely something that you should discuss with us prior to resigning, or prior to telling your employer you're not coming. Okay. So reach out to us, employmentlawyer.ca, and we're happy to review this for you and let you know whether this kind of forestalls your ability to claim you've been constructively dismissed by being asked to relocate to Edmonton from Calgary. All right, that's the time we had today. Thank you all so much for your great questions and for listening in. We had some great questions today. I hope my answers were helpful. My name once again is Lluc Cerda. I'm the managing partner of the Alberta office of Samfiru Tumarkin, the Western Canada practice leader, here to answer your employment law questions. We have another show coming up this weekend as early as Tuesday tomorrow with my colleague Sefton Liebrandt. You have the information there on the screen, 1 p.m. Eastern time. Join in, listen in. If you had a question that you didn't get time to ask today, ask it tomorrow. We'll be happy to get to your question. Thank you all once again for joining in and listening in, and we will see you next time.